Miss Representative Summers, I know you sent me to run of the show. How we rolling today?
What do you need, Mr. Chairman? Because we're ready to get started.
Yes, ma'am. I know it. I'm ready. Nope. Nope. I thought that was it.
All right, you can check your text, Mr. Chairman, so we can go ahead and get started.
I'm ready, ma'am. We can call the meeting to order.
All right.
Good morning. We're going to call the meeting to order. As I don't know who's online. Is Representative Faulkner on the line? Representative Summers?
No.
Okay. Could someone offer us prayer? I like to do that before we start any gathering, because at this time we need prayer. Could someone give that to us, please?
Let us pray. Oh, Heavenly Father, gracious God, we pause to say thank you for today. Thank you, Lord God, for unity and understanding and clarity. And thank you, Lord God, for allowing us to understand what our roles are in this capacity. Lord God, we thank you for good leadership. We thank you for bright minds. We thank you for the gentlemen and ladies who are doing this work to ensure that the freedoms in which our people died for stay in place. Lord God, give us grace. Give us under the precious name of Jesus. This is our prayer. Amen.
Thank you. Thank you so much, Representative Hines, for those words that we need at this particular time. Good morning, everyone. I want to thank you all for joining us this morning for this timely conversation in our history. There is so much going on in the world and around our state, and I really do appreciate the experts, as I will call them, that have joined us today. My name is Kabir Kareem. I'm chairman of the Mississippi Legislative Black Caucus. On behalf of our 55 members, I want to thank each of you for joining us for this timely and critical discussion. Voting rights have always been, and will always remain a cornerstone issue for the Mississippi Legislative Black Caucus. Mississippi will be as strong as her elected. And that means being intentional in ensuring every eligible Mississippian can vote without barriers, intimidation, or suppression. Mississippi was ground zero for the fight to secure the very voting rights we have access to today. Civil rights giants like Fannie Lou Hamer and Medgar Evers and countless unnamed Mississippians risked everything so that we could exercise the power of the ballot. Yet, here we are, decades later, still battling new forms of disenfranchisement and voter dilution. As lawmakers, the caucus continues to support legislation that strengthens our democracy, that includes common sense reforms like online voter registration, early voting, and fully restoring voting rights for citizens who have served their time and deserve a second chance at civic participation. Today's dialogue is about understanding what's at stake. Our panelists will help us unpack some critical questions. This is not just a policy conversation. It's about power, representation, and the promise of democracy. The Voting Rights Act is more than just legislation. It's a lifetime that ensures every Mississippian's voice counts equally. I want to thank you all again for being here. I want to thank the panelists. I want to thank everyone who helped put this digital dialogue together. The caucus is working. We're on the move. I want to thank you all for caring and for standing with us in this fight for fairness, access, and justice. Now, to get us started, please join me in welcoming our moderator for today's discussion, our very own Representative Jeffrey Harness. Good brother, you have the mic and floor.
Thank you, Chairman. Thank you so much. I am Representative Jeffrey Harness, and I have the honor of representing District 85 in the Mississippi House of Representatives. District 85 covers Claiborne, Franklin, Jefferson, and Warren counties. I'm thrilled to moderate this critical conversation today on the future of the Voting Rights Act with an esteemed panel. But before we jump into that discussion, I'd first like to introduce to you all my good friend, Representative Tamika James Jones, with an update from the House Select Committee on Voting Rights. Representative.
Good morning, everyone, and thank you again for joining us for the future of the Voting Rights Act. In Mississippi, the fight for voting rights is a part of our DNA, but it's a fight that we're still having today. Speaker White has established a select committee on voting rights, in which I'm a member of. Last month, we began reviewing 3 key issues that determine how strong our democracy really is. The first being restoring our ballot initiative process. The second one being voting rights for people with felony convictions. And lastly, the implementation of early voting. The policy presentation before the committee made something very, very clear. Mississippi is still behind nearly every other state in protecting and expanding the right to vote. Mississippi is one of only a few states still requiring legislative approval or a governor's pardon to restore someone's voting rights. More than 52,000 Mississippians, which is about 2% of our voting age population, remains disenfranchised. Between 1997 and 2024, only 207 people had their rights restored. And that's absolutely unacceptable, especially in our modern democracy. We're also one of just 3 states in the union that doesn't allow for early voting. With our ballot initiative process remaining broke, since this court decision has made it impossible for citizens to put issues directly before its voters. These barriers weaken the participation and silence too many voices. The Mississippi Legislative Black Caucus supports legislation to expand access, and we collectively carry one central truth, and that simply is our democracy only works when every voice is heard and when every vote is counted. The right to vote is sacred. Protecting it isn't just our duty, but it's our legacy. Today's dialogue furthers our commitment to defend and protect democracy. We continue to stand on this and on this call to action. And at this point, we want to tell you thank you for joining us, and we also look forward to this conversation.
All right. Thank you, Representative Jones, for that update. And now we can go to the panel discussion. Before we get started, I wanted to start off with a quote by Medgar Evers. Medgar Evers stated, "Our only hope is to control the vote. In this, he was expressing a simple but revolutionary truth that political power is the key to lasting change. That's so very true. It was so very true then, is even more true today. So good evening, everyone. I'm Representative Jeffrey Harness, and it's my honor to moderate today's discussion, the future of the Voting Rights Act, in light of the new Supreme Court case. The Voting Rights Act of 1965 remains one of the most significant civil rights laws in American history. It was born from the courage of ordinary citizens, many right here in Mississippi, who risked everything for the simple right to vote. Yet today, we once again find ourselves at a crossroads. The United States Supreme Court is reviewing cases that could reshape how the act is enforced, who can bring challenges, and how states like ours protect or restrict the right to vote. That's why this conversation today is very important. So before we begin, I'd like to ask each of our panelists to keep their remarks or answers to 2 minutes so that everyone can get an opportunity to express their ideas and we can move on to, we can get as many questions in as we need to. I'd like to introduce the panelists at this time. We have Attorney Carol Rose. And Carol Rose is one of Mississippi's most respected civil rights lawyers. And he has decades of experience in litigating voting rights and redistricting cases across the South. Our next panelist is Dr. Andre Ory, professor of political science at Jackson State University, whose scholarship explores race, representation, and public opinion in Southern politics. Then we have a good friend of mine, Attorney Jarvis Deutsch. He's executive director of ACLU of Mississippi, the leading organization statewide efforts to protect voting access, and challenge voter suppression. And we also have Amir Badat. He would also be joining us today. So please join me in welcoming these distinguished panelists. The first question I want to ask is, I want to direct to Attorney Carol Rose first. I want him to set the stage and walk us through the history of the Voting Rights Act, why it was enacted and how it changed voting in Mississippi, and some of the protections it provides. Are you there, Mr. Rose?
And I want to thank you and thank the caucus for allowing me to share some thoughts with you today. Going back to before 1965, I want to start with 1870 when the 15th Amendment was enacted. And that was one of the Civil War amendments that guaranteed that the African Americans would be treated equally to whites when it came to voting, that there would be no voting discrimination. However, discrimination existed from 1890 all the way up through 1965. And there were Medgar Evers, Fannie Lou Hamer, Mississippi Freedom Democratic Party, and others in Mississippi and others throughout the South did march and protest for the right to vote until they finally convinced President Lyndon Johnson and Congress to pass the Voting Rights Act of 1965. And the Voting Rights Act then had three primary provisions. One was Section 5, which required pre-clearance of any new voting change. And the reason that was put in there was because of the history of discrimination and the new ways that Southern whites were coming up with discrimination. Other was Section 2 to make sure that blacks could vote equally. And the other was Section 3. There were voting registrars who registered people to vote after the Voting Rights Act was passed. That's when Black people started voting in Mississippi and throughout the South and started electing people of their choice.
All right. Does anybody else want to add on to that before we move to the next question? I wanted to ask Dr. Ori, I wanted to ask you, Dr. Ori, how are we progressing? Describe our current state of voting rights in Mississippi in your words. How are we progress? Are we progressing? Are we standing still, or are we losing ground?
Yeah, so let me just go back, looking at 1965 and moving forward. We were progressing very well. 1975, the Congress passed an extension to the Voting Rights Act that allowed language minorities to be considered under the Voting Rights Act. And then we moved to 1980 after a lot of progress was made. Back in 1978, Connor versus Finch allowed blacks to be elected to the state legislature and blacks to actually elect a candidate of their choice. We moved to 1988. In 1980, they had intent, which meant that plaintiffs had to show that the structures were put in place to intentionally disenfranchise blacks. So as we moved forward, the Voting Rights Act was very successful because it said in one instance that you had to create as many majority black districts as you could. And we saw Mississippi, for example, now has the largest number of black elected officials in this country. And that is directly a function of the Voting Rights Act. So, we've seen great progress here in Mississippi. The concern is whether or not this progress will continue, given the more recent court cases. I'd like to just say one more thing. The court got it wrong when they struck down Section 5, or really Section 4B led to 5, because Chief Justice Roberts misinterpreted the data. And we can talk about that later, but he used wrong data to suggest that blacks are voting just as much as whites are today.
Okay. You got a little time to elaborate on that data, Dr. Ori. We got about 45 seconds. Could you quickly describe an example of what you're talking about?
Yeah, so they use the current population study, CPS data, and that current population study was based on survey data.
Okay.
And we know that based on the research, blacks overreport voting. And as a result, it appears that blacks are voting more than whites. But in recent voting right cases, we've used data from voter files that confirm that blacks are voting less than whites. So Chief Justice Roberts' conclusion that blacks were voting, more than whites, and therefore we didn't need Section 4B and Section 5, that is erroneous. And again, they were using the wrong data to substantiate that opinion.
Okay. All right. Thank you for that information, Doc. The next question I would like to address is to Attorney Jarvis Dortch. Attorney Dortch, the Supreme Court may limit who can bring lawsuits under Section 2 of the Act. Could you tell us what would that mean for Mississippi voters and groups like the ACLU that have traditionally led those fights?
Yeah, and thank you again to the caucus for inviting me on. We've recently won a decision to expand the number of black legislative districts, or districts where black voters can elect candidates of their choice. And we're having those special elections next week. The state of Mississippi is actually appealing that decision. They're not trying to interrupt these elections, but they're asking the United States Supreme Court to look at that question that you just raised, that it's their belief that only the Department of Justice can challenge state actions under Section 2. So private actors like the individuals that we represented have no ability to file a claim under that. And what they're really saying within their brief or their statement to the court is that Section 2 does not provide an individual right to vote to people. that despite the name and despite what's said there, that it's not clear enough that you have an individual right. And if you don't have that individual right, you don't have that right to bring that private action. They're saying that Section 2 is just some restrictions on what states can do. And that since those restrictions interfere with states' rights, that should be left up to the Department of Justice to decide when they intervene. And since states' rights are so important, that you shouldn't have all these actors out here bringing these lawsuits like Alabama here in Mississippi and Louisiana, because they don't care about states' rights, and it's too important for the process of a state, whatever it chooses, to be interrupted by just these individuals that don't have any accountability, as they put it. So it will really put us in a place where right now you wouldn't have any options, because of course this administration is not bringing any claims to protect minorities. They may be bringing claims to protect white voters or to use the Voting Rights Act in that way, but and they're not arguing that it needs to be pre-clearance. So it would be a situation where people would really have not any type of individual access to be able to challenge some restrictions that would normally be challenged under Section 2.
Okay. Thank you, Attorney Deutsch, for your remarks. Is Amir there on the call, on the
I'm
Zoom?
here.
Good morning. How you doing today?
I'm doing all right. Thanks so much for having me on.
Okay. I had a question for you. The federal courts recently ruled that the Mississippi Supreme Court districts dilute Black voting strength. Now, what does that case tell us about whether the Voting Rights Act still has power?
Yeah, so this was another case that was brought by the ACLU, and so Jarvis, congrats on the win in this case. This was a case that was brought under Section 2 of the Voting Rights Act, which Jarvis was just talking about, and which Attorney Rhodes and Dr. Ori have also been talking about. And what Section 2 does is it prohibits racial discrimination in the context of redistricting, and in particular, it prohibits racial vote dilution. So it's been an incredible protection against racial discrimination and to ensure and protect fair redistricting and fair maps at all levels of government. So it protects our congressional maps, it protects our state legislative maps. It also protects our state Supreme Court maps. And so what this case was about was whether or not our state Supreme Court districts, which had not been redistricted in decades, diluted the votes of Black voters in the state. And what a district court found was that they did, that Section 2 was violated, and that the state, in order to remedy the Section 2 violation, has to redraw the state Supreme Court districts in order to allow Black voters in at least one district to elect their candidates of choice. And so that was a big win under Section 2. It shows that Section 2 continues to be an important protection for voting rights and for Black political participation in Mississippi and across the country. And that case is going up on appeal. And I think that Attorney Rhodes and Attorney Deutsch could talk more about kind of what the issues on appeal are there. But I think the broader story here, and what I'm sure that we're going to get to in a few minutes, is that this case, the state legislative case that was also brought under Section 2, they show us that Section 2 is important, that Section 2 continues to serve as a critical protection for Black political power in Mississippi and across the country. And that is the reason why we are seeing attacks on Section 2, whether it's the attack on whether or not there's a private right of action that's going up to the Supreme Court, whether it's an attack on the constitutionality of Section 2 that's currently before the Supreme Court in a case called Louisiana versus Calais. Those lawsuits are being brought and those arguments are being made because Section 2 has been so effective in allowing Black voters to elect candidates of their choice and promising free and fair elections in this country. And so I'm looking forward to talking a little bit more about that case and why it's so important for us all to be keeping in mind as we barrel towards the midterms.
Okay, we are going to revisit Section 2 before we get through the first line of questions. Thank you for your response, Mr. Amir. I have going to go back to Attorney Rhodes. It's amazing to me that, guys, I had the luxury of passing the bar and sitting in on many meetings with Attorney Rhodes and Deborah McDonald. I was able to obtain a wealth of knowledge about constitutional law just by sitting back and listening to those two talk about it many days. Attorney Rhodes, Mississippi still enforces lifetime voting bans for certain felony convictions. From a legal standpoint, how does that align or conflict with the principles of the Voting Rights Act? Attorney Rhodes?
Yes, unfortunately, the Fifth Circuit Court of Appeals, en banc, has held that Mississippi can continue to disenfranchise certain felonies, and it does not necessarily offend the Constitution or the Voting Rights Act. And the reason for that decision is the makeup of the court. The court has changed over the years. The court is more conservative now, and it's harder to win cases in the Fifth Circuit. It's become one of the most conservative court of appeals, I think, in the country. And Section 2 has been used traditionally to give Blacks an ability to elect candidates of their choice. And Amir talked about minority vote dilution. And vote dilution essentially is when people of color vote for a particular candidate but cannot get those candidates elected, then because of white bloc voting, then and the history of discrimination and socioeconomic factors prevent them from being able to elect candidates of their choice, that there should be a remedy whereby they elect candidates of their choice. And people who have been convicted of certain felonies, disenfranchising felonies, and Mississippi's Constitutional Convention of 1890, they selected crimes that they thought African Americans are more prone to commit as crimes to become lifetime disenfranchisement. You lose the right to vote for the lifetime, and the only way to get it restored is to go through this process of getting the legislature to restore your voting rights, and that has been in place since 1890. However, the Constitution has been amended twice since then. And when the Constitution was amended, Fifth Circuit essentially said that when the Constitution was amended, that sort of cleaned up their original discriminatory intent to disenfranchise Black people and to make it so that now they're just looking at felonies that will keep people from voting, and that's a legislative prerogative and a state voters' prerogative to disenfranchise people for a lifetime. And the legislature could remedy that. And the voters could remedy that by amending the Constitution if you can ever get the initiative process to work again.
All right, thank you, Attorney Rhodes. My next question goes to Dr. Ori. Are you there, sir?
I am.
Okay. Dr. Ori, given the Holder decision, ended federal preclearance, how has that affected election fairness and access in Mississippi?
Well, There have been a number of bills that have been passed that could possibly dilute the black vote here. One is voter ID. Almost immediately after Section 5 or 4B was struck down, we had the legislature to pass voter ID. And voter ID is important because people of color are less likely to have the IDs that the state requires. That can trip some people up, including black folks, because their response is everybody should have an ID. You need an ID to get your federal aid, so on and so forth. But it's still the case in terms of the research that marginalized people of color are more likely to not have IDs. I'll give you a quick example of why that's problematic. The Metro Center here in Jackson was closed. The voter where you get your driver's license, DMV, was shut down at the Metro Center. Metro Center is in a largely populated black area. Well, those individuals, who many of them are impoverished, could not go to the DMV located in Woodrow Wilson, the one that's located in Pearl. So in effect, that prevented them from registering, and no one's beating the door down to register. In fact, that's what the research shows, that because of barriers to registration, this is one of the main reasons people don't vote. So that's just one example.
Okay. Attorney Deutsch, what can Mississippi communities do to protect voting rights on the ground, as in on the ground level? I know that you get the cases at a certain level, but before these cases get to an ACLU, NAACP, what can the communities do to protect the integrity of voting rights?
Yeah, I mean, the best thing they can do is be active and show up when these decisions are being made. Amir is on a case with us, or has worked with us on a case that we also have in DeSoto County, challenging the supervisor districts up there. And what we've been able to do is to look at how that community reacted to those districts that were proposed. And they made a number of arguments, and they presented their own maps. They made it clear that the county was choosing to not have equal representation through supervisor districts. And that is, helpful in litigation, but it's also helpful with organizing and making sure that, Black voters in those communities know that these opportunities should be there. And when they come there, like they have, with 4 Senate races up there in the special elections next week, you have an organizing that has helped put you in place where those court decisions happen. But now you have organizing that is going to help you hopefully allow Black voters to have an influence on how those races turn out.
Okay. Now, I want to direct the question to Amir, and then we can go back to the Section 2. Amir, what reforms or strategies do you see as most urgent to keep the spirit of the Voting Rights Act alive in states like Mississippi?
Well, I think that there are a few things that have already been mentioned that we in Mississippi can adopt to, fulfill the promise of the Voting Rights Act and fulfill the promise of a multiracial democracy in our state and our country. One of them that has had some traction, Representative James Jones mentioned this, is early voting. Mississippi is one of 3 states in the country that does not have early voting, and we have a very restrictive absentee voting system where you have to fit into one of a few categories to be able to actually vote absentee. And what that means is that people who are working people who have, busy schedules, have childcare responsibilities, elder care responsibilities, who might find it difficult to take out some time on one day, election day, to go cast a ballot. Those folks have additional barriers to be able to actually have their voices heard. If we had an early voting system where folks could come to the circuit clerk's office in the week or 2 weeks before election day, whenever their schedule allows, that would reduce barriers. It would reduce what we call the cost of voting for people in Mississippi. And by the way, Mississippi is oftentimes number 48, 49, number 50 on the list of states that have the highest cost of voting. And so early voting would reduce those barriers. Another thing that's already been mentioned several times is we have felony disenfranchisement in Mississippi, where people who are convicted of one of 23 disenfranchising crimes are permanently banned from voting. And these are crimes that could be as minor as, timber larceny is one of the crimes. Shoplifting is one of the crimes. And so people should not be prevented from voting simply because they made a mistake at some point in their lives. A core part of reintegrating into our society once you've done your time is being able to participate in our democracy and have your voice heard. And in order for us to really, truly achieve, like I said, the promise of a multiracial democracy in Mississippi and in this country, we have to be able to restore people's rights and have a real meaningful way for people to restore their rights, not the convoluted system that's currently in place where an individual has to have a legislator sponsor a bill that has to get passed by a 2/3 vote in each chamber of the legislature, and then the governor has the opportunity to veto it. That's not a meaningful way for people to restore their rights. We have to have a real process in place that automatically restores rights once certain criteria are met. And then, the other thing that, again, Representative James Jones mentioned at the outset that the Mississippi Supreme Court has recently taken away from us is the ability to put an initiative on the ballot, direct democracy, the ability of people to vote for policies that they want to see enacted directly rather than having our unrepresentative legislature, which has been gerrymandered in many regards, preventing us from actually having the voice of the people reflected. And so we need to restore the ballot initiative process. We need to be able to put ballots on, or we need to be able to put initiatives on the ballot that actually allow the voices of Mississippians to be heard again. And these are all three of these are live issues that the legislature is going to be considering in the next legislative session. And we need to do everything that we can to support you all in the Black Caucus. The members of the Black Caucus are going to be on the front lines of these fights. And so we need to be able to support you all and help you get these initiatives passed.
Thank you so much, Amir, for that response. I wanted to ask each of the panelists the same question, and all of y'all get an equal time to respond. I guess we could start in the same sequence we've been going in. And that question is, what could Mississippi's political landscape look like 5 years from now if Section 2 is gutted, particularly for Black, rural, and low-income voters? I'll start with, either one of y'all can go one at a time, but I guess we can start with Mr. Rhodes. Could you give us your insight on that possibilities of what our landscape will look like 5 years from now if the Section 2 is gutted?
Well, but I'm gonna take the Section 2 being gutted a couple of different ways. One is, and as Amir has alluded to, it's pending right now before the U.S. Supreme Court the issue of whether or not Section 2 is constitutional. If the Supreme Court rules that Section 2 is unconstitutional, then the political landscape for African Americans would, instead of we have a potential of adding 2 Black senators and a Black House member to make about 58 Black majority Senate and House districts. If Section 2 is declared unconstitutional, it's a possibility that we might wind up with 10 to 12 to 15 such districts. And the reason I say that is because throughout the South, there have been a lot of state legislatures that are Republican dominated that have drawn districts that are white majority. And instead of arguing that they're drawing white majority districts, they said they're drawing Republican districts where Republicans could be elected. And the U.S. Supreme Court has said that that's okay if their motivation for drawing the districts is for partisanship. That's all right, as long as it's not race as the motivation. And if Section 2 is declared unconstitutional, I can see the Republican legislature drawing districts from west to east, because most of the African Americans live on the western side of Mississippi and whites on the eastern side of Mississippi. And those are the same way the lines ran for the Mississippi Supreme Court, running from west to east to sort of dilute the African American voting strength. If if the Supreme Court does not hold that Section 2 is unconstitutional, it could weaken it in other ways, which would make it more difficult for us to maintain the Black majority district we have or win new lawsuits trying to restore or add additional Black majority districts.
All right. Dr. Ori, you want to comment on that?
Representative Harness, let me back just a second. I want to go back to respond to why Section 2 is so important and how it's been so effective. I mentioned the Mobile versus Bolden case where you had to show intent that the district the district was intentionally drawn to discriminate against the marginalized group based on race. Well, immediately after that, in 1982, Congress amended Section 2 so that you only had to show that it resulted in discrimination. And then in 1986, the courts gave an opinion in the Jingles versus Thornburg case, whereby Jingles provides specific prongs to determine whether or not a Section 2 case results in vote dilution. Those prongs include, if you can draw a compact district, a district where folks are, cohesively put together, and the issues that they face, the communities of interest, are similar. And then the most important for me, based on my expertise, is the statistical analysis, which shows that Blacks vote Black, they're cohesive. Whites vote white. They usually vote to dilute the Black vote because they're in the majority. And ultimately what it shows that if you draw a district that's a majority white, and in this case, they probably will be drawing a lot of them, because Blacks vote Black and whites vote white, there's no way that Blacks can win because they're in the minority. And so then you'll have tyranny of the majority where you have permanent winners and permanent losers. So back to Attorney Rhodes' point, you can see the dilution of the Black vote, which is by extension the dilution of, majority Black districts. And that's problematic for me. And I'll close with this. That's problematic for me because Blacks are already, or whites are already a supermajority with respect to Republicans. And to dilute, the Black districts even more, that's just problematic for me.
Okay. Jarvis, want to chime in on that?
Yeah, and just to build off that, I think if you listen to the arguments a couple of weeks ago, that they're putting the phrases and terminology out there to kind of put it make people okay with what's going to happen. Like, it's almost like the result of discrimination is not going to be enough, and that if you argue that Black voters should be able to come together and vote for a candidate of their choice. They're calling that racial stereotyping. You're saying all Black voters think the same. So you're in the wrong. One of the arguments was, they don't have, in West Virginia, Democrats don't, there are a lot of Democrats, but we don't make a district just for them. So essentially race isn't a thing anymore. It's just all partisan. So, at its worst, like Carol Rhodes said, the number of Black majority districts or districts where Black voters can select a candidate will definitely shrink. And you can see places like the city of Jackson where you have 4 senators that are based in Rankin County or Madison County. That's what we had in Hattiesburg. In the case that we brought, they cracked through Hattiesburg and split all the Black voters there. You can do something similar here, and Black voters will have the ability to vote and access to the ballot, but they won't have any power to make any change. That's at the worst end. I think for looking forward, there has to be a push from folks like in the caucus and here in states like Mississippi to push Congress if there's an opportunity again to pass a new Voting Rights Act to address some of these changes, address the changes they made in 1982, even though this current court is ignoring, the Voting Rights Act says results, not intent. But there has to be a push to address this and understand this. If it doesn't happen now, we're on a track for it to happen eventually.
Thank you, Jarvis. Amir?
Building off of what's already been said, I think that this lawsuit, the Louisiana versus Calais lawsuit that the Supreme Court heard a couple of weeks ago, is, I think, one of the most important cases of our generation because of the threat that it presents to Section 2 of the Voting Rights Act. And I think we have to make the stakes really clear. If the Supreme Court rules that Section 2 is unconstitutional, it will decimate Black political power across this country, and specifically in Mississippi. We have seen that the MAGA-controlled Republican Party is ruthlessly pursuing redistricting to maximize their political advantage, and they will not hesitate to undermine Black political power wherever they can in order to secure a permanent majority in the House of Representatives and across state legislatures in the South, including in Mississippi. And so we, along with Black Voters Matter, published a report a few weeks ago that showed that the Republican-controlled Congress, in the Republican-controlled Congress, we could lose up to 19 seats where Black voters currently have an opportunity to elect their candidates of choice in the South if Section 2 is declared unconstitutional. And the same thing would happen in state legislatures. And what that means is that in Congress, that would lock in one-party control of the House of Representatives, essentially eliminating the opportunity for Black voters to have true representation in the House. In Mississippi, what that would mean, as Attorney Rhodes and everyone else on the panel has already said, we would significantly lose the number of legislative seats in both the House and the Senate where Black voters have an opportunity to elect their candidates of choice, and it would essentially put Black voters in a permanent super minority status in the legislature. And what that means is that in real terms, things like Medicaid expansion, restoration of voter rights, fully funding education, those things would most likely be off the table in the legislature because it would be impossible to get enough of a majority. It would be impossible to get a majority behind those types of things as the priorities of the parties are currently constituted. And I think we also have to be clear that the other side is chomping at the bit to make this happen. We've already seen the Louisiana legislature call a special session specifically to move back qualifying deadlines and election deadlines in anticipation of the Supreme Court ruling in this case. We have seen in Mississippi the state auditor making posts online, encouraging the Republican legislature to redraw our congressional lines, to draw Congressman Thompson out of his district after a decision comes down in this case. In South Carolina, the Republican candidate for governor wrote an op-ed saying that the state should, as quickly as possible, move to redraw Representative Clyburn out of his district in anticipation of a decision in this case. And so this is one of the most important threats to voting rights, I think, that we have seen in a long time. And if we do get a decision where the Supreme Court guts Section 2, it could look like a number of different things, and it could do it in a number of different ways. But the Black Caucus, the members of the Black Caucus, are going to be on the front lines of redistricting fights next year, or whenever this opinion comes down, because we will see legislatures move quickly to try to redraw maps, and the members of the Black Caucus are going to be our biggest champions in the legislature to try to prevent the worst from happening and try to protect as much Black political power as we can.
Representative Harness, can I get 30 seconds?
Sure.
So one thing I didn't mention in terms of the importance of Section 2 is that it relies on scientific evidence. And that has been one of the most important elements in this use of Section 2. You provide statistical analyses, you have cartographers to come in and draw maps based on formulas, and you have historians to come in and provide qualitative data. So I just wanted to mention that was a way that we beat many of these cases. I guess we're 2-0 this year in the state. But it was because we were able to provide the empirical evidence and the historical evidence.
Thank you, Dr. Uri. That's very important that you bring that up, because everything that we do as a caucus, either Democratic or Black caucus, is a lot of things that we do is to gather data to be used in court decisions. That's why it's very important that, as Amir just stated, that we work together in this fight. This is not a time for. Amir has just painted a dark road that could possibly be the future of the Voting Rights Act. And it's a dark road, it's a scary road, but we can attack it if we work together and we come up with a game plan. Before we
Can I just add one more thing? I apologize, Representative Harness. Just one more thing I wanted to add on this.
Okay.
30 seconds, I painted a dark road of what we're facing, but we still have the opportunity to fight here. We still have the opportunity to prevent the worst thing from happening. And that's going to look like, we need to be out in the streets. We need to be taking actions. We need to be making it clear to the justices at the Supreme Court that they cannot gut Section 2 of the Voting Rights Act, that they should maintain the ability of Black voters to elect their candidates of choice. And if they decide to weaken Section 2 in some way, we have to mobilize quickly to support you all in the legislature and to make sure that our elected officials understand that we do not want discriminatory redistricting maps passed in Mississippi or anywhere else in the country.
And I think you just answered the last question before we go to questions and answers, Amir. I really appreciate you for that response. And I agree with you 100%. Before the last question, before we go to questions and answers from the audience, is, and this is just for one moment of reflection, we talked about Medgar Evers' words, "Our only hope is to control the vote." Could I get a quick response from the panel? What does that mean at this moment? Our only hope is to control the vote. What does that mean to you, Carol, as at the moment, as what we're facing with the Voting Rights Act?
Well, for the past 40 years, whenever I've had to give addresses or speeches to the NAACP, I've always said that the right to vote, use it or lose it. And what I meant by that was that if too many people have fought and died for their right to vote. And if we have people who do not use their right and go out and vote, no matter how difficult it is, then we will eventually lose it. And it looks like we're almost at that time.
Okay.
Yes. So,
Doc?
first of all, gaining the right to vote is one thing. We need to maintain our ability to vote and vote effectively, because when we vote effectively, we get what we call descriptive representation, which is we get folk that look like the folk who are voting in those majority black districts or majority marginalized districts. And then it's substantive representation. That means that you have folk at the table who can provide some type of information that speaks to the issues that impact their constituents. And in some instances, it's educating those legislators that are in the legislature who may have not known about these issues because they're not in those districts. So, that's important that, we keep fighting, like others have said, whether it be in the streets or whatnot, op-eds, so on and so forth, because that's important.
Thank you, Doc. Jarvis?
Yeah, I mean, I was just thinking about, I know you guys are going to be together and Black legislators from across the country in Biloxi in December. I think you guys really need to understand that this could happen quickly for y'all. Depending on what the court says, many of y'all are going to be in what people can allege are illegal districts. And
Right.
they can, if the legislature doesn't even want to, you see private actors, despite what Mississippi is arguing, start trying to enforce those states to do it. I hate to say it, I've served with y'all. Some members are only interested in maintaining their seats. And if this doesn't get them to act, nothing else will. And y'all have to act together because, we've seen in every other state that there hasn't been an appeal to doing the right thing that has worked. What they did in Texas is, they ran that through quickly, despite all the evidence that they were discriminating against Hispanic and Black voters. Because, you've got different type of people in power now. You got folks like Shad White who will post, bye-bye Benny, just casually after a Supreme Court argument, not even caring about the representation that 40% of your population has in Congress. Just, bye-bye Benny. I don't know how you appeal to those folks unless you start making this real to the people they do listen to. And if that means, taking positions on other places, you can't operate like things are normal anymore, especially if this decision goes one place. Like, you're not voting on stuff in a vacuum. When you vote to cut taxes, it's not happening in a vacuum. You need to think about how this impacts your community going forward and what your vote actually means. And to withhold that vote isn't just withholding it for those tax cuts. You need to withhold it to have your ability to be a member of the Mississippi legislature and for your folks to have representation. Things could get really serious over the next year. So
That's correct, Jarvis. Amir?
Yeah, I think I already talked about this a little bit, and I jumped the gun. Sorry about that. But I think that we need to be ready to fight. This is going to be a fight that's going to happen fairly quickly, like Jarvis mentioned, and we need to be ready with all of the information, the data, the legal analysis, the organizing capacity, the communications capacity to be able to wage this battle. Because in my view, this lawsuit, the attacks that we're seeing on Section 2 and on voting, they're not only a threat to Black political power, they're not only a threat to free and fair elections in our country, they're a threat to our existence as a democracy. And I don't say that to be hyperbolic or to try to exaggerate the stakes at all. I truly believe that these are that within the next 5 years, if we don't do what we need to do, then we'll be living in a very different country. And so I really appreciate the work of the Black Caucus and the work that you all have done in the legislature. And I urge you to continue to do that work to protect Black political power, to work with us, advocates in the state, to try as hard as we can to protect Black political power and the promise of our democracy. And I can promise on my end I will make myself available however I can, and so will Fair Fight to help you in that fight.
All right, thank you very much. That's going to end the questions that I have. At this time, we will take questions from anyone that's listening in. I have a question from Mr. Kentrell Liddell. His question to the panel is this.
Yes,
What
it's Dr.
steps
Liddell.
can be,
Thank you.
excuse me?
Oh, yes, good morning. It's Dr. Liddell. Thank you so much.
Dr. Liddell. Okay, okay, I'm sorry. I see Dr. I don't see Doc. I didn't see Doctor.
No, that's fine. I was letting you know I'm a woman.
Okay, yes, ma'am. Yes, ma'am. What steps can be taken to improve African American voter apathy? Or meaning a lack of interest on the part of Black voters in participating in the political process? That's a good question. Very, very difficult question. But anyone care to take a jab at that?
Yeah. So I asked that question years ago when I was up in D.C. doing an internship, and Tony Harrison, former legislator over in Alabama, I said, why are Black folks in the Mississippi Delta so apathetic? And he jumped all over me. He said that apathetic means that people understand and know. In this particular case, many folk who are not participating in the political process are not impacted. Well, they don't know that they're impacted so much. So, for example, President Obama was president, and for some folk in the Mississippi Delta, nothing changed for them. So now we have the SNAPS benefit issue. That may be something that, provides the impetus for, some Blacks who typically would not vote because of the cost of voting relative to the benefits. So, I think that this particular issue may be one of the issues that gets some of these voters who typically don't vote attention.
That's a good point. Anyone else want to take a jab at it?
And I just like to add, right after the Voting Rights Act was initially enacted in 1965, there was education that was taking place within Black churches and Black communities about not just registering and voting, but why, the reason to vote, and how electing certain people could affect policy in the long run. They might not feel it now, but they might feel it in the long run. And we don't have those educational pieces taking place throughout our communities, in the churches and other places anymore, and informing our constituents about the need to vote and why it is important, and also to hold our elected officials accountable.
I like that one, Dr. Kara. Accountability. Some of us need to be held to a higher standard for sure. Okay, Jarvis, you still on?
Yes, sir.
What does that mean to you, Mega Elder's quote, my good friend?
I thought you were gonna ask me about how to hold y'all accountable.
Well, you can answer that too if you want to.
I mean, back to what Dr. Ori was saying, you go into these communities and they see a lot of Black elected officials in these small towns, and they ask why hasn't anything changed, but they don't understand what job these Black elected officials have and what power they have and how much power the state has in determining, how much money goes into roads and bridges in a community, or what's invested in a community. And, they don't know that the state is pumping $50 million in roads into Madison County, even though Madison County doesn't need the assistance, and they're not giving it. So they're blaming their local elected official, and they are, in their mind, rightfully questioning what's the point of voting if nothing's going to change, and we got y'all all elected. So there does need to be this serious undertaking of educating people on what the process looks like. And I think people that run for office sometimes don't really want to get into that, because they're running personally to say, I'm going to fix things, but without wanting to explain, I'm going to try to fix things, but I need this to happen too, because that's complicated. And you also are, thinking people don't want to hear that argument, but, you're not going to go to the legislature and fix stuff. You're going to go to the legislature and vote in the House with 63 other people to pass legislation. And that's how it works. You need numbers. But you have a lot of lawmakers, especially in the legislature, are like, I need to get something from my district. And despite, being very clear, it's just math that you vote together, you get more. You're limiting what you can do for your district actually by being so selfish and looking at your district as your own state. I mean, I used to leave my district and drive through about 8 different districts on the way there. People don't know what district they live in most of the time. And, the benefit isn't going to stay within your confined lines in your district. There's a lot of work that needs to be done, and it's, community-based organizations, but also legislators and lawmakers need to do it. You guys usually don't run in general elections. And so when there's that need to go out there and talk to voters before an election in November, that's not happening across the state, because everybody's in districts where everything was settled during the primary. We lost the governor's race by like 25,000 votes. If you had lawmakers in these individual districts out there working as if they were on the ballot, you're going to generate that 25,000 votes and win in that other space.
That's very true.
So my thing is, you got to go work. Like,
we got to work.
Yeah,
I think that's a very good question that Dr. Liddell asked. We could spend a whole session on voter apathy alone, and it's a very hard situation that we have to face, and we have to face it head on. I don't think that we face that voter apathy issue head on a lot, like we should. And that's probably the most glaring issue that we have in our community is voter apathy. And I'm glad that question was raised. I don't see any more questions from the audience. And
Representative Hines has a question.
Okay, Hines, I'm sorry. What is your question, Hines?
First of all, good morning to everybody. I apologize. I'm not technical savvy like Representative Harness. I would like to know what the panel thinks is an appropriate response when you have colleagues who are supporting the causes of the other party at detriment of growth for our particular party, but at the detriment of the growth for African Americans. What should be the proper response or approach to dealing with that particular member?
Well, that's a tough one, Representative Hines, because of individualism. And that is that some of these, or the primary incentive for any legislator or elected official, rather, is to get reelected. And in some instances, they see the opportunity to get resources in their district by leveraging their vote. And I'm not sure if that ends up being the case, but sometimes, individualism trumps collectivism because, its primary issue is to get reelected. And if they can bring anything to their district when they otherwise couldn't, they will deflect.
Jarvis, you want to chime in on that?
Not really. Thank you.
Representative Harness, Chairman Kareem has a question.
Okay, Chairman.
Thank you, Madam Secretary. Thank you, Chairman Harness. Look, and this is directed and kind of a follow-up on Representative Hines' question. My question is two parts, and I'll take the latter, ask the latter first. In that same vein, but don't we have to look at the collective instead of individuality? And I think that's something that society has told us, look out for yourself and not collective for everybody. And I think that's where we've gotten sidetracked. I can't rise no higher than my brother, and my brother can't rise no higher than me until we all are free. And I think the mindset has been, you get yours, don't worry about your fellow man. And I think we have to go back to looking at the collective as a whole, because everything that's been stated today is getting ready to decimate Black representation throughout this country, particularly here in the South. But I want to direct this to Dr. Ori. You being a political science history person, haven't we been in this space before after Reconstruction? And kind of elaborate, what did Black folks do to bring us to this point? Well, not to this particular point, but to Black representation that we have now.
Yeah, so as it relates to, how we got here, I referenced that earlier in terms of the various voting right cases that were gave us a favorable opinion. But I'd like to go back to this whole individualism and collectivism issue. The American ethos of individualism is at the forefront of the founding of this country. And so others that do not subscribe to collectivism look at pulling themselves up by the bootstrap. I agree with you that there should be collectivism, but one thing I've observed is that, for example, if legislators are not getting any bills passed because of them being in the minority, then those individual legislators are trying to get things for their district, and that's how they end up with this individualistic approach, where they then reach out across the aisle. And in some instances, that results in only them and their district, or them receiving some benefit that does not impact the collective. So I think that's just a part of nature, and where we are in society now, individualism is one of the biggest problems that's facing African Americans.
Okay, I want to chime in, and I think that Carol and John and Representative Hines Carol spoke to accountability, and Hines spoke to what do we do to those individualists as voters, and how do we combat that issue of individualism in our community as it relates to legislative individualists. What are we going to do about that? I think that's what we're trying to. I think that's what we're trying to read out. We're trying to see, what do we do about that? What actions can be taken, short of. I don't want to talk about what we could do, but what things can we do to improve that issue that we have with legislators politicians. That also creates voter apathy, you know. And we ended up, we were given these protections in the 60s, and then we end up with people that are not using these protections in the right way. So does anybody have an answer to that? Want to chime in on that before we leave?
And Representative Harness, Representative Scott has a question. That'll be our last question.
Okay. But does anyone want to speak to what do we do to these individuals?
Representative Hardis, I think, a big part of this is going to be like an internal thing where it's party politics, caucus politics. You guys got to figure out a way to have, power or leverage over folks. And I know a lot of people, get up there and they're like, I don't want to be told how to vote. And that's not exactly what's going on. But if you watch Congress or you watch other state legislatures, there's an acceptance that this is the way legislatures work, that you're not an individual, you're a member of a caucus. That's why these caucuses exist. You don't go up there as just 122 individuals in the House. So that's like that's an issue within party. But external to that, I think when things happen, we do have to say why it's happening and not just say it's a supermajority thing. And, because some things pass without the supermajority. We do have to be, and with organizations like ours, if we're going to do advocacy work, we have to be honest and say why something happened. And, some people are going to resent that, but, that's our job. That should be our job. And our job is, these jobs that I have are pretty important. And, if people aren't going to like you because you're willing to say what actually happened, that just comes with it. But, it's a lot of it is just what leverage can you have over folks to make them, stick with the group. And in the Mississippi legislature, y'all don't have a lot of leverage. The speaker has a lot of power. The lieutenant governor has a lot of power. So it's a very difficult thing for y'all to be able to do that.
All right, thank you, Jarvis, for that insight. Miss Representative Amira Scott, I believe she has a question, final question. You want to take us home, Ms. Scott?
Yeah, it's been a very interesting discussion. I wanted to ask, I'm trying to be clear. Attorney Rose, there was some discussion about the Republicans being able to draw districts on a partisan level, this is your political belief. If that is the case, then should our response not be the same thing? When there's an opportunity for us to draw 58 or black majority black districts, it doesn't matter whether we take somebody down from 90% to 60%. They just have to accept it. But if we have an opportunity to draw 58, 59, and I'm not saying we can draw that many, but but have that total in the House and the Senate, could we not have applied that same reasoning and draw districts that would be Democratic districts? Because we do make up 40% of the state, and I just wanted to see what was your thought on that.
Well, I have two thoughts on that. One is drawing partisan districts if you're drawing Democratic districts, and the other is drawing districts where the community, people of color, can elect representatives of their choice. And I prefer drawing districts where people of color, Black people in Mississippi primarily, can elect representatives of their choice. And it does not take no supermajority or packed district in order to be able to elect a representative of choice, which means that those who hold these positions or elected in these districts have to be unselfish and have to look at trying to increase the number of voices and representation within the legislative body, rather than looking out for your individual selves to say, I want to make sure I get reelected. And so I need as many Black people in my district as possible. And so when redistricting comes around, and we've gone through this in several cycles, where we tried to unpack districts in order to give more Black voters a chance to elect people of choice. And we run upon different representatives and senators not wanting to give up a 90% district down to 65 or 62. And as time goes on, a lot of we don't need as many Black people in districts, because as Black folks get better economics, better education, and understand the process, you might not need a 65, 70% Black majority district. You might be able to elect with a 52, 55%. And so we have to get people to be unselfish and willing to do that. Now, with respect to what the Republicans are doing, and they're doing this not just in Mississippi, but they're doing it nationwide. What they did in Texas at the urging of the Department of Justice was to eliminate 4 Black and Latino districts. In Missouri, Republicans are eliminating Black majority districts. And they're drawing districts because they say they're drawing Republican districts, and they're cracking concentrations of Black and Latino. So they're doing this across the country. They're going to do it in North Carolina. They're doing. The governor of Indiana has called it, and it called a special session for them to do it there. And at some point, they might do it in Mississippi, to where they, especially if the Supreme Court strikes down Section 2 of the Voting Rights Act, I can see the governor calling the special session to redraw the legislative districts to try to get more Republican districts. And so in that process, our Black members should be willing to look at the greatest good for the greatest number, and not be selfish to try to pack as many voters in their district as they can.
And I guess my last thing to you, Attorney Rhodes, is that it is the terminology, I guess, is what I was looking at. So our goal is to continue to draw Black districts, even if we have to say it's we're using the same terminology that they're drawing Republican, so we're gonna draw Democratic.
Oh yes, but
Our
understand.
goal is to draw as at least as many as we have now and more. Would that be our goal?
Yes, if you're looking to draw Black majority districts. And the reason I was saying that, there are some within the Democratic Party who believe that you don't necessarily need Black majority districts to elect a Democrat. You can get 30%, 35, 40% Blacks within a district and elect a white Democrat. And what I was talking about was the Black community being able to elect candidates of their choice that they would want, rather than a party wanting to elect white Democrats.
Yes, sir. And I want to be clear. I'm drawing Black districts, Mr. Rhodes, and you know yourself in what we're operating under now. You got 30 influence districts in there right now. So if the Democratic Party want them some white boys to run or some white girls to run, they need to get out and recruit them some white girls to run and some white boys to run in the 30 influence districts that they got right now. It's 30 districts, 30 or more, 28% or more right now in this state, in the House, that they could run. So that influence district crap is crap. And I'm glad y'all recording so you can play what I said. It's crap. And if they are wanting, if white folks are wanting to do this, they need to get out and get them some good white Democrat men and women to run in these existing 30% or more influence districts? Because you know yourself, Mr. Carol Rose, they are there.
Oh, Representative Scott,
Yes, sir.
if I can just add to your original question, and Attorney Rose, you correct me, but Cromartie, there was a Cromartie case. Well, first of all, there's Johnson versus Miller that said that race cannot be the predominant factor. And then the Cromartie case came back and said, well, in this particular case, they weren't drawing the districts based on race, they were drawing it on party. Now, those were Democrats. And so drawing a district based on party, that's something that Attorney Rose would have to, convince the court. But it was, based on my recollection, it was the Democrats who actually came up with that that strategy, which I thought
Well,
was
I'm a Democrat and have been one for 50 years. But and we'll go when you come to Providence Church and I'm laid out in front of the altar there, I'll still be a Democrat. But let me say this. Our goal in my mind is to do whatever we have to do to maximize Black districts. Now, whatever the terminology is, whatever strategy we have to do, and that, to me, that's what we need to be thinking about now, how we're going to make that happen. And I still say to us Democrats, because we had a member just said the other day on an interview with Mississippi Today, that we ought to be looking to elect Black Republicans and have these influence districts. And I said to myself, has this person looked at the map that we're operating from now? Because Mr. Rhodes knows, and I'm sure you know, that there are at least 30 House districts that are at 30% and more. If that is the threshold for an influence district, sir, we already have that in the map now. So what we need is people to run in those districts. That's what we need, in my mind.
But I do agree with Attorney Rose in terms of Black legislators being willing to reduce their districts as it relates to majority Black, the number of Blacks in that district. There used to be what we call the 65% rule when Frank Park and Attorney Rhodes were litigating some of these cases. 51%, of course, a majority. Then you had 5% based on age requirements. You had another 5% based on who was registered, and then 5% based on turnout. And because it affected Blacks disproportionately, they say it creates 65% districts. And I think it was Senator Hardin saying, if you can't win in a 55% district, then you don't need to run. Now, I don't know what that percentage is, but I do think in some of these hyper supermajority districts that they should be willing to reduce the numbers of Blacks in those districts to your point, to buttress those influence districts.
And the last thing I would say to you, since you're from Jackson, when Ed Blackman was trying to get the Jackson people to reduce their districts, senators and representatives, they went ballistic. I hope you're recording this. You can play it again, and I'll say it again. Some of them are still there, some of them are gone, but they know that they did. And some of them sitting in 88% Black districts and didn't want to go down to 72 and 75. This is what the man was proposing, not to take them in the 60s, and they wouldn't do it. So, Dr. Ori and Jarvis Dortch, I'm like my mama say, charity begins at home. Y'all need to let your charity start there. That's where we need some real education, because we could certainly make some real changes there, particularly with the Delta losing population up there. But this has been a very interesting discussion, and I appreciate having the opportunity to be on it.
Thank you, Representative Scott. And we need to really talk about that issue more as same as voter apathy influence districts. And I agree, we need to do a better job of recruiting. If we have influence districts, we need to recruit some white candidates, or they need to recruit them, or we need to recruit them. We all need to play our part. But with that being said, I think the chairman stated that we're going to be here for an hour and a half. We went about 5 minutes over, but I think we started about 11:05. So with that being said, I want to thank all the panelists. Carol, I want to thank you for your wisdom. We appreciate all the work that you've done for in the area of constitutional law. Dr. Ori, I really appreciate you. There couldn't be a Brown versus Board of Education. There couldn't be any movement on these lawsuits, constitutional lawsuits, without political scientists, psychologists, and people of that nature. We appreciate the work you're doing as a professor and leading the fight for civil rights. And of course, Jarvis, my friend, appreciate you for all the things that you're doing. I want to thank Representative Summers for helping put this together. And I want to thank everyone who participated. And now this time I will turn things over to Chairman Kabir Kareem.
Thank you, Representative Harness. And, you know, when we came up with the digital dialogue, we used to do this back in the during COVID. And I think this is something that we can use as a resource tool to keep folks communicated, informed on what's going on. But I want to be clear before I close this to the panelists. If the Supreme Court ruling is passed tomorrow, the Mississippi legislature can come in and redistrict Black district at will, like they want to. Is that clear? Did I understand you all correctly?
If they strike down Section 2, the legislature could come in and say they want to draw more Republican districts, thereby eliminating the Black majority districts.
And they can do that
as many as they can.
As many as they can. I just want that to be clear to let our caucus know and the public know the fierce urgency of now and what's going on. So again, I want to thank you all for the panel discussion. Great job, Representative Harness, moderating. I want to thank, before I go, our sponsors and partners from yesterday's hearing. We had a great hearing on Black maternal health, Sixth Dimension, and Black Women's Roundtable for helping us yesterday. I want to thank the panelists. I want to thank all that attended. I want to thank caucus members who are standing on business and always supporting the cause. You all have a safe weekend. Look, we've got another crisis with this SNAP program situation in our community that we have to be mindful of in our respective communities. We need to figure out how we're going to stand in the gap. With that being said, everybody have a good weekend. Don't eat too much candy on this Halloween, and everybody have a good evening. Thank you so much.